Hi, I'm Esther.
And I'm Sean.
I write about AI news here at TechTarget.
And I edit Esther's stories.
We're here to talk to tech experts about everything AI, from open and closed models to AI agents and who's ahead in the generative AI race.
And even the elusive AGI.
We've got it covered, right, Sean?
Yep, we've got it covered.
Hello, everyone, and welcome to the Targeting AI podcast from Informa TechTarget. Today, we are talking to James Cooper and Kompella. James is a professor of law at California Western School of Law in San Diego. He is also a research fellow at the Singapore University of Social Sciences and a visiting professor at the University of Heidelberg in his Master's of Law program in Santiago, Chile. He has served on the U.S. government delegation to the World Intellectual Property Organization Advisory Committee on Enforcement. Kashyap is a CEO at RBA2AI, a tech analyst firm, and an AI advisor for enterprises, public sector agencies, and venture capital funds. And fun fact, this was the second time on the podcast, and we're very excited to have you again. Both guests are co-authors of a new book, A Short and Happy Guide to Artificial Intelligence for Lawyers. Thank you both for joining us on today's podcast. And thank you for sharing your book, which was really awesome.
James and Kashyap, what inspired you to write this guide for lawyers on AI technology? And when did you get the idea for it? And when did it actually come out? Just last week or at the end of last year?
Just at the end of last year. And we're just so excited to be here. Thank you both, Esther and Sean, and to everyone who's watching. Good evening to Kashyap in India.
So Professor Cooper has been teaching law, obviously, for more than 2 decades, 3 decades now. And we've together taught some courses, together and separately taught courses and conducted masterclasses across the world for law students, practicing lawyers, and professionals in the legal sector. These courses are around transformative technologies and AI. And we saw that there was an urgent need to upskill lawyers on AI. So that's one of the ideas why we did this book. And the second thing is, I've written a book on AI for managers, practical artificial intelligence about 6 years ago. And then you see that there are thousands of books on AI for managers, AI for software engineers, etc. And there are also hundreds of research papers and hundreds of books on AI ethics and responsible AI. But how do you actually move AI ethics and responsible AI into practice? You have to move them through. Lawyers are a big part of that equation. But there are hardly any books on such an important topic for such an important group of stakeholders. So that really was the genesis of trying to see we should do a book on AI for lawyers. Professor Cooper?
There are a couple of kinds of books that are out there, whether it's the cheerleading books or the doomsayers, the folks that are looking at these nightmare scenarios with AI. And we wanted to write something that would be practical and helpful and kind of demystify what AI tools can do for lawyers, for judges, for law enforcement officials. So for us, it was very important to make it accessible for law students and for those who, like myself, been in the sector for more than 3 decades, but also make it fun, because it can't just be jargon and it can't just be, forgive me, Cash, a data science, because it's got to be practical. And so our combined skill sets, I believe, were the right combination. And there's not a lot out there that's practical. And there are millions of lawyers worldwide that are going to have to use these tools, that are using them now, that need to use them in an ethical way, need to use them to help their clients. And we thought this was a marketplace that we wanted to help.
Isn't generative AI one of the biggest use cases for it? Right out of the box was law, writing drafts of memos and briefs and motions. Was that an impetus as well, since the immediate application for law was immense?
Indeed, this is the world's slowest profession, meeting the world's fastest technology. So that you're absolutely right. This was a natural sweet spot. But there's a ton of other areas, whether it's a criminal sentencing prediction, recidivism models, facial recognition, due diligence for closings in a transactional setting. It's indeed, as you say, Sean, it's about drafting, but there's a ton of other areas in which AI tools can play a really transformative role.
Quickly researching case law too? Doing a quick cursory, is that another application or?
Let's keep the lawyer in the loop on that one. We're still not free of all hallucinations, but there's been a ton written about that. And the very famous case of President Donald Trump's former fixer, Michael Cohen, using it to try to get off probation. Last year, he was using, I won't say which tool, but it hallucinated a bunch of cases. But even in closed environments, we've seen major research tools hallucinate their results. So yeah, you want to, it's a great tool to assist, but you don't want to rely on it totally. And you want to, as President Reagan used to say, trust but verify. Of course, he was talking about nuclear weapons from the Soviet Union. This isn't nearly as serious, but there's still a lot of professional responsibility and ethics concerns that we want to address. So a human in the loop, a lawyer in the loop is still very important.
What are some of the key themes in the book that are important for enterprises, lawyers, and even consumers and everyday users of AI?
I think Professor Cooper already alluded to lawyer in the loop. So the enterprise AI managers and professionals be very familiar with this concept of human in the loop. So similarly, we have this concept of whether you're using AI in the legal field or you're helping your clients. Lawyer in the loop is an analogous construct. So the core themes of the book are we're looking at AI in different practice areas of law, be it criminal law, be it commercial law, be it IP and copyright law, employment law, consumer law. So there is no field of law that is going to be untouched by AI. So we do a survey of the different applications, the different challenges, and the different questions and new disputes in each of these specific areas of law. So that's like the bulk of the book. We also have the last part of the book really moves towards solutions, which is really about the need to have responsible AI standards. And the way to implement our way to get to responsible AI is really through smart regulation. Not just any regulation, but smart regulation. That's again one more theme. But overall, the broad theme is that AI in law is an idea whose time has come.
If I may also add to what Kaushal is saying, and that is, when we talk about AI, when I was growing up in the 80s, AI meant Amnesty International and the human rights, the seminal human rights or non-governmental organization. And I think that's also a piece to this, which is how can we protect human rights in this process, whether it's the environment, whether it's indigenous people, whether it's women and students, the traditionally marginalized, but basic civil and political rights, the right of privacy, the right to be forgotten. How do we protect those rights in this AI, new AI, artificial intelligence environment? And I think that's something that we're constantly bringing light to and trying to shed light upon, but also think through with our reader, because we don't have all the answers. We have a lot of questions, and we have approaches that can help in terms of responsible AI, ethical AI. But the challenge of this book is, this goes to Sean's earlier question, we've been writing it over the last year. Things were constantly changing exponentially. And so it's like surfing. You don't want to fall over your surfboard. I live in San Diego, so we surf here. You don't want to pearl, which you want to figure out where the wave is going to crest and then break. And we're still at that stage. In the middle of our writing, the European Union had the audacity to pass the EU AI Act after many years. And a complete surprise to many of us that they actually got it done. So how do you kind of plan into that? And by the way, it's an amazing piece of legislation for all 27 member states of the European Union, whereas the US is still we have a blueprint, which is kind of like a plan to have a plan to have a plan here in the US, which is unbinding, non-binding, and sounds more like a faculty meeting than an actual way to deal with AI.
So what key challenges, impediments, problems do lawyers face today using traditional AI, which might be the old predictive analytics or predictive AI, and generative AI? Also, what are the key benefits of how Gen AI and AI can help lawyers?
So I'll start off, and Professor Cooper can continue after that. So the legal sector is not an early adopter of technology, and that's rightly so. While the AI world and the technology world's ethos is move fast and break things. And rightfully so, the legal sector is more cautious in embracing technologies. But when push comes to shove, the legal sector has shown that they can adopt digital and other technologies. Like during the pandemic, there was a lot of a switchover to cloud and digital and such technologies. So before we get to the question of what does really the legal sector get by adopting AI, but before that, there is an even more fundamental question. The rest of the society in every domain and every industry, be it banking, retail, telecom, etc., has embraced AI and has adopted AI in quite a significant way. And these are actually the clients of lawyers. These are the lawyers are expected to help. And they're looking to, as they encounter questions of law in different AI use cases, they're looking to the lawyers to help them answer those questions. So without the lawyers upgrading themselves on AI, there is no way they're going to be able to help themselves. But we have to understand that the law school curriculum is really not teaching AI or any technologies to the students. So there is a huge skill gap. So if you look at one of the biggest challenges that we see, bridging that skill gap is a big problem. And we've called this in our book as well as elsewhere in our commentary that law schools really need to step up and impart the students with those skill sets that are required for the age of AI.
A little bit earlier last year, we wrote a piece for Law.com, American Lawyer Media, that Kash Up cleverly titled "The 19th Century Called It Wants Its Curriculum Back." And the truth is, we're using the case method, which is a great way, the case law method from Christopher Columbus Langdell, former dean of Harvard in the 1870s, wrote the first case book. It's a great way to learn law, but it's not the only way. And it's not practical for today's world, that we learn more and more about less and less, the finer points of appellate decisions, and we distill legal principles from those appellate decisions. That's a great way to learn law. Here's another way to learn law, and that's through skills, which is seen as kind of dirty and not doctrinal and therefore not worthy of the same kind of tenure, the same kind of benefits for the legal professoriate class. But it's the truth. That's what our clients are going to need. And that's what the lawyers who are going to serve those clients are going to need. And so we're trying to bridge that with this book and with some of the courses that we've been teaching around the world. Singapore, Poland, the Ukraine. Professor Kompella and I have taught as part of the Center for American Studies out of Poland with a lot of Ukrainian students. We're trying to find ways to empower students, just like blockchain should naturally mean there should be smart contract law, not just contract law in the legal curriculum. Well, likewise, the skill sets of prompt engineering, of knowing how to use these AI tools and the dangers that come with them should be rote in law schools now, right from the first year. And those legal academies, those law schools around the world that embrace this idea are future-proofing their students. They're not going to have to play catch up. And that's really where we stand on this. And part of our, as Professor Kompella has argued, is to get the law professors on board, just like we need to get legislators on board. And if you've been doing something the same way for 3 decades, 4 decades, very tough to teach old dogs new tricks.
Okay, quick follow-up. It just occurred to me that both of you guys have a profound international orientation, right? Working across borders, presumably across different legal systems too. So does Gen AI and AI work the same in any legal system, or does it have to be adapted to the local legal code?
That's a great question, Sean. I'm a comparativist. I've done most of my work in Latin America, a little bit in Asia and Africa, but working with Kashyap on the subcontinent, because India's got such a huge number of amazing lawyers, we've had to bridge some of those cultural differences. But there are things that remain the same across cultures that are transnational, and that is duties to clients. And part of that is competence. The competence, and competence includes whether it says it in your ethical rules of professional responsibility or not, that you've got to represent your client in the best way. If that means using AI, you better use AI. That means knowing all the tools that are out there that the prosecution or the other side in the civil case is going to be using against you and your interests. So there is a crossover. Now, attorney-client privilege, when it can be used, there are differences even within Western countries between, say, the European Union in terms of attorney-client privilege and in-house counsel versus how the US or Canada might work. The same thing even within the Anglo-American common law. But at the end of the day, the tools are increasingly the same, and the need of our clients in terms of addressing their businesses, their rights to privacy, their civil and political rights are going to be the same. So there is a lot of crossover here. Professor Kompella, could you expand on that?
That's a great question, because a lot of the large organizations have operations in different countries. So they have to deal with this question practically on a day-to-day basis. So we're actually writing a second book, which is a follow-up to this book called AI Governance and Regulation. In this book, we talk about the regulatory differences when it comes to AI for the 3 key jurisdictions of the US, EU, and China. But we're going to be looking at 25 other jurisdictions in our next book, which is coming out in April or May of 2025. That's AI governance and regulation. So when it comes to generative AI specifically, how does the use of previously copyrighted material to train those models, is that fair use or not? So the approach of different legal systems differs. So that's just one point. And even related to that, the importance that is given to data privacy varies across different jurisdictions. So that is again one more fundamental difference that companies that are working across borders have to deal with. There is also the requirements, probably this is too esoteric for our audience, but does data localization violate the principles of data transfers that are international trade? So there are lots of nuances to unpack, but yes, definitely you need to be aware of the different treatment of AI and data across jurisdictions when you're a global organization.
Does definition of fair use differ from country to country, possibly?
For sure. In a place like Japan, for example, you can scrape whatever you want with virtual impunity currently, versus here in the US, we're still working out. There's endless numbers. There's over 30 really important pieces of litigation going on across different jurisdictions in the US, whether it's OpenAI being sued by the New York Times or Sarah Silverman suing Meta. There's no shortage of contingency fees waiting to be collected. But at the same time, there's going to have to be some harmonization, and that may happen through the World Intellectual Property Organization, through the WTO, through international rulings. And at the end of the day, global commerce needs predictability. It needs a sense of concreteness that we're not yet there. This is an important year, 2025, that will, we hope, provide some of that clarity. If not regulatory clarity, then judicial clarity. Now, the downside of that is judges, as good as many of them are, may not be IP specialists, may not be futurists, may not be, for sure, are not technologists. A lot of them still have 12 o'clock flashing on their VCRs at home, metaphorically. Are those the folks that we want to make those rules because of a lack of regulatory clarity? Probably not. But that's what we're left with. And they're doing really important work and should be lauded for that work. And the other piece of this that we still haven't talked about is the tech nationalism. We're talking about industries that will dominate the future, or technologies that will help the dominance of certain industries. So there's a geopolitical context to all of this as well. And so from an intellectual property point of view, how you file, who can file, whether it's an AI tool, can be a co-filer or a co-applicant on certain patents, that's still left open, and we don't know the answer to that. But what we do see from the vagaries of globalization is that certain jurisdictions are going to be more permissive, or a lack of regulation may be a strategic advantage. No different than, say, a lack of child labor rules or a lack of environmental enforcement, so-called social dumping in international trade literature. You're going to see more and more of that, I think, just like for blockchain. Malta, Estonia, Singapore, other countries, because of a lack of regulation, are places where capital formation and companies are citing themselves so they can take advantage of that lack of clarity.
I wanted to piggyback of something that you mentioned earlier, Cash App, which is the idea that I guess the legal field is not the first when it comes to technology, and kind of jumping on technology. How do you kind of mirror the two of using technology to take the bar exam versus, and then also I spoke to some lawyers who are also kind of using it to the idea of maybe they're still not up to par when it comes to AI and technology.
Right. I think this is going to be a slightly controversial take. I'm not the first one to say this, but the business model of the legal sector, the law services, the professional services, is on the billable hour. So if you have productivity enhancing tools, if the number of billable hours that you can charge to a client comes down, there is an incentive not to use those. So are you going to use new AI tools to cut the number of hours you're going to charge a client by half? So that's one of the reasons why the sector has not traditionally embraced new technology, and that's no different with AI. But like I said, AI in law finally seems to be like an idea whose time has come, because the clients really are asking for it. There is a lot of pressure from the clients to say, why don't you use AI to bill us less? Suppose using these new technologies, because there is an opportunity. What is stopping you from doing it? There are also certain startups who are trying to offer these solutions. So now there is a little bit of a competitive element as well. But in general, I think the philosophy of the legal sector is not that you should move fast and break things. Because I think across legal systems, the fundamental principle is that let the innocent not be punished.
Which leads to a different point that Kashup's alluding to here, and that is any transformative technology is going to invite resistance, whether it's from the bench, from judges, or whether it's from old school lawyers. And you saw this with DNA testing or ballistics, or going back to the medieval times of the trial by ordeal, which we would burn people at the stake or throw them in with, if they floated, they were innocent, but if they drowned, they were obviously guilty. These sort of medieval inquisitorial type old so-called judicial proceedings. We have new ones like oral trials and the right to cross-examine your witnesses and the right not to be tried twice for the same crime, and a bunch of other due process rights which are enshrined in the 1966 International Covenant of Civil and Political Rights. So too AI engenders this kind of resistance because it's a game changer. And it can be used for good. It can be used by nefarious actors. In the legal sector also, it can be used by big law, or it can be used by solo practitioners. It's a game changer if it's the latter, because it can provide better access to justice. If we think of it as not billable hours and you're at a nonprofit or public interest, you're a public defender, you're not charging in 6-minute increments, a tenth of an hour for your time, this is completely liberating. If you're big law with high rent in downtown buildings and very expensive art on the walls, then you're going to be worried.
Interesting.
I think Professor we should talk about our manifesto as well.
Oh, yeah, in the book, A Short and Happy Guide to Artificial Intelligence for Lawyers by Cooper Kompella, we have our manifesto, which I'm going to read to you now, which is really about access to justice. It's written with the Martin Luther King Jr. legacy in mind. We say, we have a dream that one day solo practitioners, mega law firm partners and their minions, corporate counsel, judges, law enforcement officials, judicial sector administrators, public interest and non-governmental lawyers, and public sector attorneys will understand artificial intelligence and technology and drive its adoption rather than react to the AI tools being imposed upon them. As such, there will be greater access to justice, more efficient provision of legal services to all levels of society, and appropriate and effective legal aid to all, regardless of income and station in life. And so this builds on all the access to justice work that has been done around the world for decades. AI can be a game changer in terms of provision of legal services. It's not just a developing country problem. In the U.S. itself, particularly rural areas, people don't have access to justice. The numbers are staggering. And it's not a surprise then that Sustainable Development Goal number 16 from the United Nations, among the 17 Sustainable Development Goals, is access to justice, is the provision of legal services. And if you can get access to justice, you can have confidence in at least one branch of our government, the judiciary, if not the legislative or executive, and you can get at least your day in court or your day in arbitration. Of course, as we continue to use AI tools in those areas too, we have to query whether the receivers of our entreaties and petitions are ready for access to justice. But from the provision by lawyers of legal services, AI tools can be transformative.
I like the minions part as well.
I'm thinking like a junior associate, paying back student loans and spending all night in their offices.
That's cool. That is a cool manifesto.
Switching over to facial recognition, part of your book covers facial recognition and the FTC, the Federal Trade Commission. What role does the FTC play in facial recognition, and why is facial recognition a fuzzy subject?
So yes, our book does talk about a couple of cases, I think, about the facial recognition technology. Let's be clear, like facial recognition technology, like other AI technologies, is never going to be like 100% accurate. There are going to be false positives, there are going to be false negatives, and there is going to be like misidentification in any AI technology because of that. So false positives and false positives are given. So the FTC has come out and said there have been 2 cases that the FTC has highlighted in last year, 2024. One is a vendor of these facial recognition-based technologies. They say don't misrepresent your claims. So just as I've outlined, there is going to be certain errors in the technology. It will work well in certain cases. It doesn't work well in certain cases. So if you are making claims that go beyond that, better be grounded. Otherwise, we're going to come after you based on existing enforcement powers that we have. So that's case one. The second case, an earlier case, which is really about a pharmacy company using facial recognition technologies. Here again, the main message that comes out is that don't implement such technologies without putting adequate guardrails in place. So that is again one more thing. So like I mentioned, alluded to smart regulation, like as what we call for smart regulation. So our approach, our philosophy has been that if there is harm that's going to be caused, or potential harm that is going to be caused because of AI, maybe there is already some rules on the book which can be used to curb that misuse or that those practices. You don't really have to have wait till new regulation comes in place to be able to do that. So I have some implications for enterprises based on this, but Professor Cooper, you want to add specifically with respect to the law issues itself?
Yeah, really what we're talking about is some of this technology that can embed or amplify existing discrimination in our society. And we want to avoid that. We want to take away biased data or the biased interpretation of the data or the biased lens through which the data is being looked at, and not reinforcing that, because you don't want, this has to be a liberating technology, AI, not a, hey, let's make society even more unfair. So there's that. The second point that Professor Kompella is kind of pointing to is that existing watchdogs, existing legislation, whether it's the Federal Trade Commission or whether it's employment laws or fair credit and lending laws that are already in legislation, that are already on the books, can be used in the AI context. And that's an important part. We don't always need to re-regulate. Smart regulation's awesome, but if there's already something there, it's even smarter to find prosecutors and government lawyers in the civil side to use those tools, those pieces of legislation from an enforcement action point of view. And that's why the FTC case against the pharmacy company was so important from a racial discrimination using facial recognition. And the 5-year ban on using that was the agreed settlement in the case last year. Really important. And kudos to the FTC. It wasn't, in our judgment, overreach. And it's using, and the other case about the claims, it's about advertising and making sure that you're not falsely representing what your software can do. So these aren't huge stretches in terms of the jurisprudence. Now, the real test will be, how do we look at other kinds of technologies that aren't currently covered by legislation already on the books? And that's where there'll be some opportunities or potentially, depending on how the new administration deals with it, some challenges as well.
Okay, so can we go back to the New York Times case? So I'd like you guys to talk about where that case stands. We haven't heard much about it recently, and also how the outcome might influence legal standards around copyright and IP, and how much ambiguity still exists about generative AI, copyright, and IP, because I think nothing has been cleared up yet at all.
It's in the middle of litigation is the best way to say, and we're not going to look into a crystal ball and figure out what's going to happen. And some of these cases need to be fully litigated, and we need to get a sense of where the judiciary stands on it so that we can react as legislators, as our elected officials, can then have reasoned responses. And that's the kind of give and take and checks and balances that exist in our democratic system between the three branches of government. Now, what's, for me, the most interesting point of all of this is the role of legacy media companies. They couldn't control the internet and missed their opportunity to make the kinds of licensing agreements that would have avoided things like Napster and Bit.com and those file sharing cases from 20, 25 years ago. This is, in a way, a roaring back of some of those legacy media companies, and rightfully so. If you punch into a generative AI tool, give me a New York Times-like article on topic X, and it spits you back what is almost a New York Times article on topic X, that's suspect, some would say, with respect to intellectual property, and may not be fair use. And that's what these cases are going to be about. Can you scrape the web, even in terms of licensed materials, and have access to it for the purposes of generative AI? I suspect we're going to see legacy media companies do quite well at the end of the day, but we're not looking in our crystal ball. That's just my sidelines guess. but there's a huge windfall for those companies if it goes their way. That's why a lot of companies are moving to places like Japan that are more permissive in terms of what you can scrape and what you can't. Professor Kompella has a different spin on this. Please go ahead.
I think I think the issues of whether it is fair use or whether it's not fair use also depends on the technology, the underlying technology. So, for example, to constitute fair use, there has to be transformation, right? There has to be transformation of the original text. So the nature of this transformers technology, this generative AI, is that again, experts are divided because you can actually replicate something that is very close to the original material, but in a vast majority of the cases, probably that's not what's going to happen. So it's just really interesting to see how first the judges and then the legislators are going to. So it's probably, meanwhile, what are the practical implications? Let me talk about that, I think. We will see more content licensing agreements. I think there was a news item maybe a couple of days ago which said that one of the large LLM providers, they said, okay, going forward, we're not going to use material for which we don't have the rights to use. So that is something already it is shifting. But if you're an enterprise, you want to use generative AI tools, but you may also be worried about what are the implications for you on this thing. So I say, if you're a large enterprise and you have some negotiating leverage, read the licensing terms and see if the vendor is going to offer you some indemnity clauses. It may not be to the full extent of the damage that may come out, but if somebody else is going to bring a claim against you, at least is there some partial indemnity that you can get from the AI vendor whose tools you have used. And before that, there is a spectrum of AI tools, some of which are slightly on the more expensive side, that they may have used copyright material, that they may have used data for which they have copyrights to train their models. So if you're worried about that, consider using such tools. And also make your employees aware of what are the permitted tools and what are not the permitted tools. I've talked elsewhere about this notion of shadow AI. We've heard about in the last decade, shadow IT, where employees are bringing their own devices to work. But now employees are bringing their own AI tools to work, AI apps to work. So clamp down on that practice and say, okay, what is acceptable in our enterprise context? What is not acceptable in this enterprise context? So these are some of the things that you can do at this point as an enterprise to cover some of that risk while it is still being litigated.
Nice. You kind of touch a little bit on this, but obviously you guys work in different jurisdiction, but also you're well versed in international as well. So there's a section of the book about AI in the US, AI in China, and AI in the UK. What is the difference between the way AI technology is handled in those three countries?
It's really, and this is what Professor Kompella was talking about moments ago, it's about mitigation of risk. The EU AI Act is all about different levels of risk, high risk, low risk, and in two areas in between. And so they're using risk. Other countries do it by sector. Other jurisdictions look at regulation by sector, and others look at it through national security. And so there's a couple different ways to slice this up. But the comparison is important because it's your approach. If you're more Wild West, anything goes, say the U.S., as long as it stays within the ambit of certain national security strictures, then you'll be more permissive in how you view the use of AI tools than, say, in a place where intellectual property rights, les droits moraux, moral rights, issues of the right, not the right to be forgotten, and the GDPR, the General Data Protection Regulation of the EU, are enforced. And then you've got China, or the People's Republic of China, which is more geared towards scientific socialism and to maintain power structures that exist currently and for nothing to threaten those structures so that there's a harmony between all of them. They use words like harmony. Now, other countries or jurisdictions like the UAE or the Kingdom of Saudi Arabia or Brazil, everyone has certain legal cultures that play themselves out in their respective AI laws. And keep in mind, there's a national industrial policy piece to this as well, which is, hey, tech nationalism, we want the servers to stay in our jurisdiction. We want to be able to control data flow from a national security point of view, but also from a industrial policy point of view, because if it's our data in our jurisdiction, we can use that data for a bunch of reasons, surveillance being one of them, but also for development, for large language model tools and so forth. So data to be scraped. So those are strategic advantages or competitive advantages against other jurisdictions. What's bouncing up against that, and our partnership, mine and Kasha Kompella's partnership, is a combination of, you've got two jurisdictions and two cultures blending. And so much of AI is that. You've got data scientists in the United States with graduate degrees from the US schools that may be nationals of the People's Republic of China or of Brazil or of the EU. How do you deal with things like intellectual property rights and the timing of filing? And this is into the weeds now. Those practical issues are incredibly important to make sure you perfect your security interest in your intellectual property and from an IP strategy point of view.
See, the US has had federal regulation and guidelines, not AI specific, but some other existing regulation. There is state level regulation, there is local level regulation. So now the next administration has announced a new czar, okay, in quotes, for AI and crypto. So I think there is understanding that probably the rules of engagement need to be cleared. But if I were to go out on a limb and say, probably you can expect a more industry-friendly regulation and rules going forward in the US. And from an enterprise point of view, I'd like to emphasize that AI governance is going to become a critical success factor of large initiatives. There is going to be risk involved. There is going to be legal team involved. I think enterprises really haven't been paying much attention to AI governance, but I think that is going to be very important going forward. And Professor Cooper talked about national priorities. So what's interesting to see is that in China, for example, it is very state-led. What the private sector also has to focus when it comes to AI is driven by the policy that is set out by the state. So they've said they want to focus on manufacturing-oriented sectors. So a lot of research, a lot of the thing is going towards that sector. And it's quite interesting to me that there is export regulation. So powerful GPUs are not available to China. So that has again all sorts of consequences. There is a black market in GPUs where they were being exported to place B and then subsequently imported to China, etc. That was happening. But also there was this new model called DeepSeek that has come out from China, which is interesting because they said they're able to train models, large language models, at a cost of about $5 to $7 million compared to about $100 million stateside. So that's orders of magnitude different. And they published a paper on how they've been able to do it in the absence of powerful GPUs. So that's like a wild card in what the economics of the LLMs are going to look like globally going forward in 2025. So one last thing I want to say is that Professor Cooper and I have written a piece called A Memo to the New US AI Czar. It's published in a few papers a couple of weeks ago. So that will be interesting, where we lay out a 10-step plan of how to sustain AI and how to make sure that AI thrives in the US.
And legal cultures also impact everything from privacy law, not just national security law or industrial policies, but even employment issues about how we handle occupational health and safety as enlightened legislators, how and as governments trying to provide public goods like employment standards and health and safety regulations. So these ideas of transnationality are important, but at the end of the day, national jurisdictions matter. National jurisdictions are the way we enforce. Yes, contracts become important, and business relations across enterprises that are multinational in their transnational corporations, cross-shareholding, all those sorts of different corporate vehicles to ensure harmonization and eventually compliance. But it's national jurisdictions at the end of the day. That's how we do taxes, and that's how we do criminal law enforcement.
That's a great note to end on, and we look forward to looking at your memo to the new czar, Esther. Maybe we can do something with that from a news point of view. But thank you guys for being with us so much, and we hope your readers will be happy after reading your book, and I'm sure they will be, pun intended. To our listeners, please check out James and Kashyap's book. on Amazon. And for us, please share and subscribe to the Targeting AI podcast on Informa TechTarget. Thanks for being with us again, Kashyap. Thanks for that book. I'm looking forward to reading it. Thank you so much, James. You guys were awesome. And we'll see you, all of you, back on the Targeting AI podcast.